So let's get started with our discussion and overview of contract remedies. Whenever a promisor breaches a contract, the promisee is entitled to a remedy. Now that remedy may be $1, nominal damages. It could be a very substantial amount of money. It could even be specific performance. The most common remedy, and the one I've put on the board because of its commonality, and we'll spend the most time on, is expectation damages, which require the promisor to pay an amount of money that would put the promisee, or the injured party, in the position the promisee would have been had the contract actually been performed. Generally, courts will not require a party to actually perform a contract. That's called specific performance, and it's uncommon, but in special cases, like, for example, the sale of land or a transaction involving unique items, a court may require specific performance from the promisor. Courts may also do something called a negative injunction, which is forbidding something. We'll talk about that at the end. If the contract specifies an amount to be paid in a breach, that's called liquidated damages. And so that's actually a good drafting technique, and we'll see how that works as well. Courts will usually look to the liquidated damages first, unless they constitute a penalty. So those are the big themes. And so let's begin with a brief review of breach. A review of breach. So remember that any failure to perform a contractual promise is a breach. In other words, contracts demand complete performance. Nothing less than complete performance will suffice. However, the amount of damages that will be paid directly relates to the extent of that breach. Recall that the promisor's failure to perform, the promisor's breach, may in some cases excuse the promisee from performing a promise in exchange. Most commercial agreements are structured as mutual and dependent promises, which means that the promisor's promise to perform is conditional on the promisee's performance. For example, Alex promises to pay $5,000 to Brian in exchange for Brian's promise to repair Alex's roof. If Brian never shows up for work, does Alex have to pay? No. Of course Alex doesn't have to pay, but why? Why is Alex's promise of her payment of $5,000 excused? Because Brian's non-performance of the roof repair, his non-performance was a breach, a failure of an implied condition precedent to Alexa's promise to pay Brian. And under the doctrine of substantial performance, Alex only has to pay Brian if Brian substantially performs. If Brian does not substantially perform, but instead materially breaches, Alex does not have to pay unless and until Brian cures the breach. If Brian does not cure within a reasonable time, he has totally breached, at which point Alex can cancel the contract and find someone else to do the roof repair and potentially sue for expectation damages. Note there are many other reasons other than a material breach why a promisor may not have to perform, and we learned many of these: repudiation, insecurity, excuse, impracticability. These doctrines are covered in other lectures, so for this lecture we're assuming at this stage that the promisor does have to perform, yet failed to do so, failed to completely perform, and therefore we are dealing with a situation where there is a breach. Next.